Welcome to Celebrity Estate Showdowns, recent celebrity wealth transfer litigation battles unraveled. We're thrilled to have you join us today. Before we begin, I'd like to take a moment to introduce Nancy Sanborn and Brian Joy of the Sanborn team. Nancy and Brian have been the official sponsor of this section since 2006. Nancy and Brian, please feel free to say hello.
Thank you, Teal. Hi, everyone. Being based in Los Angeles, we've had the opportunity to represent many public figures and celebrities over the years. One thing that always stands out is that once we begin, the celebrity fades away and the responsibility remains the same.
Whether our client is a living person or it's an estate, famous or not, our focus is always the same. Protect the asset, honor the process, and guide the transaction with clarity and care. That perspective is especially important when we look at these celebrity estate disputes, because behind every headline is a situation that is very similar to what all families face every day.
Thank you all, and we look forward to the meeting. And please know that your referrals are always appreciated, and we look forward to working with you in 2026.
Thanks, Nancy and Brian. In addition to the Sanborn team, the Trust and Estate section is also sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, and Pickford Escrow Company. Now I'd like to turn things over to Laura Zolnikov to provide this month's legal updates.
Thank you, Teal. Good afternoon, everybody. My name is Laura Zolnikov, and I'm a partner at Velasco Law Group, which will soon be known as VZ Law. And today I'll briefly highlight two California appellate decisions that are particularly relevant for probate and trust litigation practitioners. Both of these decisions that I will speak about were published in late 2025. First, the estate of Bodman. This case confirms that a probate court may deny the appointment of a nominated executor based on misconduct that occurs before formal appointment. In this case, even though the nominee was expressly named in the will, the court found that his post-death but pre-appointment conduct, specifically the mismanagement of estate assets and interference with business operations, demonstrated his unfitness to serve as a fiduciary. The key takeaway is that courts may consider pre-appointment behavior under Probate Code sections 8402 and 8502, and testamentary preference will not override demonstrated fiduciary unfitness. This case reinforces the probate court's broad discretion to protect estates where misconduct is shown. The second case that I would like to highlight is Gammo v. Merrill. Here, the Court of Appeal held that a prevailing defendant in a financial elder abuse case may recover cost of proof fees under Code of Civil Procedure section 2033.420. Importantly, the court found that such fees are not barred by the Elder Abuse Act's unilateral attorney fee provision, which only benefits prevailing plaintiffs. The court distinguished attorney's fees from cost of proof sanctions, explaining that the latter serve a separate purpose, promoting efficient litigation and discouraging unreasonable denials of requests for admissions. As a result, defendants who prevail at trial may still recover those fees when appropriate. In sum, Bodman expands the scrutiny placed on nominated fiduciaries before appointment, and Gammo provides an important litigation tool for defendants facing elder abuse claims. Now I'll turn it over to Jordan Parr to introduce our esteemed speaker.
Thanks, Laura. Now on to the program. Today's speaker is Vachi Zechin. Vachi is a partner at Jeffer Mangels, Butler & Mitchell, LLP, and a State Bar of California certified specialist in estate planning, probate, and trust law. His practice centers on sophisticated trusts and estates litigation, including breach of fiduciary duty claims, surcharge and trustee removal actions, will and trust contests, creditors' claims, conservatorship and guardianship matters, and elder abuse disputes. He represents a broad spectrum of clients, fiduciaries, individuals, and charitable organizations, navigating high stakes and often emotionally charged matters with precision and clarity. In addition to litigation, Vachi's practice includes trust and probate administration, where he advises trustees, handles the probating of estates, and resolves disputes among fiduciaries and beneficiaries. Please welcome Vachi Zechin.
Thank you, Jordan, and thank you to the Beverly Hills Bar Association for having me. I'm very happy to be here today to present to our esteemed bar in trust and estates. I know and work with many of you. We've got a great practice, so it's a pleasure to be presenting to you. The presentation today is on celebrity estate showdowns. I'm going to put up the slideshow now, and there is a question and answer feature at the bottom of the screen. If we do have time towards the end of the presentation, I'm happy to answer some questions. If not, once we're done, please feel free to reach out to me if we don't have time, and I can answer any questions you might have, but hope you enjoy the presentation. Let me switch over to the share screen. Okay. So we're going to talk about 3 celebrity cases
Hi,
today.
Vachi.
Yes.
It looks like the screen is not being currently shared through Zoom.
Let's try that again. How about now?
I don't see it. Oh, and yes, we are live. Thank you so much.
Great. Okay. So during this presentation, we're going to discuss some recent estate disputes involving celebrities, which many of you may have heard of on the news, talk about the impact of these cases, the lessons to learn for different practitioners, not just attorneys, but also the various professionals that we work with, fiduciaries, accountants, experts. Again, insight about these cases to navigate our complex cases more effectively, and to look how we can apply these case examples to our own practices to protect our clients and provide them a better service. So the 3 case examples that we're going to talk about today are Tony Bennett, Jimmy Buffett, and Rupert Murdoch. So let's start off with the Tony Bennett Trust. Tony Bennett, of course, everyone was familiar with Mr. Bennett. He was a legendary singer. He died recently, a couple of years ago, at age 96. Lived a long, successful life, 20 Grammys, millions of records sold. So very successful career. After his death, there was a trust dispute between Mr. Bennett's son, Danny, who was his longtime manager and trustee, and other members of the family, essentially regarding control over his estate and benefit, um, um, eh, uh, including his music catalog, his royalty rights, his name and likeness. And so this all was before the New York courts, where Tony resided. So the dispute was primarily about Tony's 2 daughters, Joanna and Antonia, filing suit against their half brother, Danny. Danny was the appointed trustee and the son, claiming that Danny was mismanaging Tony's trust and estate. Um, um, the daughters filing claimed the estate was worth about $12 million based on the estate tax filings and the 706 and so forth, but it should have been worth in excess of $100 million. So that right there is obviously a big difference. Right off the bat, there's a critical misunderstanding of what the estate should have been worth, which probably prompted the daughters to bring this lawsuit. And there were claims of mishandling of the intellectual property, self-dealing, misappropriation, claims of breach of fiduciary duty, unjust enrichment by the son, seeking accounting by the son, and trying to remove Danny as trustee. Danny objected, claiming that he was just acting at his father's direction and that he received reasonable compensation, and he wasn't doing anything wrong. So let's talk a little bit about what the trust provided. So Tony first executed his trust in 1994, and he amended it on a couple iterations, last amending it in 2016. If you look at the trust, it's pretty ordinary in that we're used to seeing trust disputes when one beneficiary ends up receiving a lot more. Son gets everything, daughter gets very little, or vice versa. But here, if you look at the trust on paper, it was equal. It was pretty ordinary, right? So that in and of itself doesn't mean you're not going to have a dispute, as we'll talk about. There were other issues beyond just the plain language of the trust. But the estate plan divided the estate essentially equally amongst the 4 children, divided the personal property equally, $900,000 upfront to each child at death, equalization for any gifts made previously to children, and the intellectual property administered in equally for Tony's children, and the residue divided equally. So again, an effort to treat everybody equally. But so what was the issue here? The issue primarily was in terms of the accounting, the management of the trust. So complex, large estates like this, when they're managed by particular family members, especially when you have these blended families, half siblings, and so forth, like you do here between Danny and the sisters, it created suspicions over, is Danny managing the trust properly, and those suspicions made way for a lawsuit. And so what happens there when you have we're often dealt with that situation where a client comes to us and says, I think my father's estate is $100 million, but my brother who's managing it says it's only 12. He must have stolen money or he must have done something nefarious. There's no other explanation other than that. And so what do you do? What do you do in that situation like that? You can file a lawsuit and make the material allegations that end up being wrong, or you can ask for an accounting first to understand what's going on. And so in this case, there was a request for an accounting, and the beneficiaries have a right to an accounting. And so I often encourage my clients, um, don't just shoot in the dark. You have a right to an accounting. Get the accounting, make the trustee tell you what's going on, and then you'll have a more informed position to say what's right and what's wrong. Maybe some of your concerns are not actual issues. Maybe some are. Make the trustee account to you if you have that right to an accounting. So in California, many states have similar provisions as to who's entitled to an accounting and what the accounting needs to contain. In California, that's set forth in the probate code in section 16060 and onwards. The precise statute that talks about the right to an accounting is probate code section 16062. And it says that the trustee shall account at least annually of a termination of a trust, change of trustee, and the accounting is entitled to each beneficiary to whom income or principal is required or authorized in the trustee's discretion. Now, that last sentence is important because trusts oftentimes contain remainder beneficiaries, contingent remainder beneficiaries. So not anybody who's named in the trust can ask for an accounting. It's whoever's currently potentially entitled to income or principal. Um, and I want to distinguish between revocable trusts and irrevocable trusts. Um, Beneficiaries are not entitled to accountings of revocable trusts. The probate code's clear on that too. So the typical husband and wife, they're alive, they have a trust. Beneficiaries, the children don't get to demand that their parents account for their assets. It's a revocable trust. The parents can change their mind, they can terminate the trust, they can change the trust an infinite number of times. It's revocable. You don't get a right to an accounting. Here in this case, Mr. Bennett had passed away. And after Mr. Bennett passed away, all these provisions in the trust vested. And so it was an irrevocable trust at that point. And so there were rights for the daughters who were entitled to an equal cut of the trust. So they were entitled to income and principal to demand an accounting. So we're in the latter situation, an irrevocable trust. There's another issue which we'll talk about. It's the right to compel a de facto trustee to account. So another question is, if you have a right to an accounting, what's the scope of that accounting? Does it start at death? Can you go to a period prior to death? And so here, the daughters claim that Tony Bennett was diagnosed with Alzheimer's disease and lacked capacity as of 2018. So that was about 5 years prior to Mr. Bennett's death. And they claim that Danny was acting as the trustee, the de facto trustee during that time. So the question is, do the daughters get an accounting from 2018 onwards, or do they get an accounting from date of death 2023 onwards? And so this really hinges on judicial discretion of whether or not the court agrees on the claim of a de facto trustee. So oftentimes you'll see that allegation being made in the pleading, such as it was here, and then it's up to a court to decide whether the scope of the accounting should go back to any time prior to the death. What I recommend is to have two prayers for relief. Ask for an accounting from date of death, which is an absolute right if the probate code entitles you to it. And then secondarily, ask for the pre-death accounting so that because if the court needs to have a trial on capacity to determine the de facto issue, you don't want to hold up the whole accounting in the interim, you can at least get the benefit of the post-death accounting while you're trying the pre-death issues. And proving incapacity, as many of you know, it's a complicating issue. It can often take years to get to trial on that issue. And so that's not going to be something that the court can quickly adjudicate, whereas post-death accounting is something the court can give you rather quickly. What is a de facto trustee? How is it proved? A de facto trustee is someone who's serving as trustee prior to the time that they were authorized to serve as trustee because of the incapacity. So in this case, the sisters claim that Danny was doing all the work for Tony, and Tony had no idea what was going on. So it's not that Tony was properly delegating duties and asking Danny to help, but Danny just took it upon himself to become the trustee because Tony lacked that ability. So that's the issue that needs to be proven to the court. What's the consequence of being a de facto trustee? Now, if the sisters can prove that Danny was in fact acting as trustee since 2018 because Tony lacked capacity, then the consequence of being a de facto trustee is that all the regular rules and regulations and duties of a trustee are imposed upon Danny. And so the court will treat him as if he was the trustee. So if he mismanaged the trust, he's responsible. If he misappropriated assets, he's responsible. And so Danny can't say at that point, well, I wasn't a trustee. You can't have it both ways. You were either acting or you weren't. And so once the court makes a determination that somebody's a de facto trustee, there's consequences. So for estate planning practitioners, litigators, how do you avoid this issue of the de facto trustee? I think the estate planning documents should be clear about trustee succession and what the rules are as to who serves when, what's deemed to be incapacity, what's deemed to have a succession plan in there for the trustee, and to have perhaps a trust protector, to have somebody watching over the current trustee. If you have somebody like Tony Bennett, a famous celebrity, to have those right advisors in place so you don't end up with maybe this unknown situation where he might be at home lacking capacity and someone else is acting as trustee and no one knows about it. So you want to kind of plan, especially for older celebrities, older people with large trusts. You want to have that framework in place and the right advisors in place so that you're not having these convoluted arguments over whether someone was a de facto trustee or not. You want it to be clear who the trustee is. And if that person can't act as trustee, you want it to be clear as to who's to receive notice and who's next in line. So this is an actual paragraph from the petition itself as filed with the court. A big issue in this case was the intellectual property because Tony Bennett, being a singer, his music catalog, similar to other celebrity cases like Michael Jackson, I mean, their name and likeness, their music catalog is the most valuable part of their estate and what's going to generate revenues moving forward post-death, oftentimes becoming more valuable post-death. So the daughters were very unhappy about the handling of the intellectual property. And as you'll see here, they alleged that before Tony's death, so the de facto trustee issue, Danny orchestrated the sale of Tony's name and likeness and his royalty stream in his music catalog that was held in a limited partnership that the trust owned. And they claimed that Danny made millions of dollars in commissions from the sales and that it was a self-dealing transaction, that he sold these intellectual property rights for below face value, and that he did it because Danny was in desperate need of money. So they accused him of a fire sale, orchestrating a below market fire sale because apparently Danny needed the money. So that was their allegation. The daughters claimed Danny improperly sold Ignite Music Fund, and they claimed that Ignite had all the name and likeness rights, and he shouldn't have done that. And so, and this was reported in the news. Variety reported on March 19, 2024, that Tony's music catalog had indeed been sold, and so there was some publicity on this issue at the time. And the daughters claimed that Danny needed the money, so he sold it for below fair market value. And the daughter said he could have made a better deal, was the claim. And so that brings us to, so this is something that would be shown in the accounting, by the way. So if the daughters claim, well, we think he sold the royalties and we think he did this and we think he did that, you ask for an accounting, and the accounting would include the ledger, starting ledger of assets, ending ledger of assets, and sales in between. So if there's any change of any types of assets, of real property was sold, if intellectual rights were sold, and so an asset now is cash sitting in a bank account, that would all be contained in the accounting. And you can request all the substantiating materials as to like real property, the closing statements, any contracts to purchase. You can ask for all that documentation to understand the circumstances of the purchase, to what was it sold for, what other offers were there, and so forth. So that's all part of the accounting process where the beneficiaries can learn about the circumstances of this sale that they're questioning. So now that the beneficiaries have all the information, how do they prove their case? So I mean, here the daughters are claiming that these assets were sold way less than what it should have been sold for. And so that's when the litigators get the experts involved. And so there's valuation experts where this is what they do. So they have their different valuation methods to say what this intellectual property right was worth. And so each side, typically in litigation, each side would get their own expert. And so the sister's expert would say, based on my analysis, and explain that valuation method to the judge, I think the music catalog was worth $100 million, and that it was and it shouldn't have been sold for 12. And then Danny's expert's going to come in and talk about how it was only worth 12. And so you're going to end up with competing experts using different valuation methods and arguing why something was worth more or less. So a judge is going to hear two experts. So what's the judge to do? Typically judges can hear both experts and can make its decision on which expert they think was right and which one was wrong, which one was more credible. What some judges could also do is use what's called Evidence Code 730, where the court itself can appoint an expert and say, well, I'm going to try to shortcut the battle of the experts, and I'm going to ask the parties to agree on a court-appointed expert, or the court's going to appoint its own expert to come at this from a more neutral standpoint. And then each party, of course, has its right to have a rebuttal expert if they think the 730 expert's wrong. But from some judges view a 730 expert as more credible for purpose of trying to get to the chase. Again, you have somebody saying 100 million, somebody 12. You've got two experts with very different viewpoints. So some judges might use 730 to get to the chase there, but it is going to, I mean, the parties are going to have to rely on experts to try to argue over what these things are worth. And then the court's also going to have to discuss, consider what discretion did the trustee have to sell the digital rights. So you have to look to the trust itself as to, did Danny have the right to sell these assets or not? Typically, trusts have very broad standards as to the trustee's management of its assets, whether to sell assets, rediversify, reinvest, whether to hold non-income producing assets or not. And so a trustee can come in, look at the portfolio, and make a business judgment rule on what the trustee thinks it's best, whether to keep a particular asset or not. So it may be that the trustee has the discretion to sell an asset, but then the question is going to be whether that was a prudent decision or not. Again, if the trustee sold $100 million music catalog for 12 million, the court could say you had the right to do that sale, but you sold it for an imprudent price. And so, of course, experts would be used to try to prove those damages. If a court agrees that it should have been sold for somewhere near 100 million, but the trustee did a fire sale for his own self-serving benefit, the court can sanction the trustee that difference. But that raises the question of what's the standard of the court considering the prudence of a trustee's business transaction. And so there is a business judgment rule. The court does provide a trustee slack, so the court's not going to play Monday morning quarterback and assess a transaction today based on what the trustee was dealing with 5 years ago. The classic example is real estate, of course. It goes up and down. So if the real estate market is a lot higher today than it was 5 years ago, the court's not going to say, well, it's you breached your duties by selling the property 5 years ago. So there is a business judgment rule. The court is going to provide some leeway for a trustee to do its job in administering the trust and exercising its discretion. And ultimately, the court's purpose is to determine whether the ultimate decision was prudent or not within the trustee's business judgment rule. And of course, with valuations, many of you deal with valuations in different contexts. And so if a 706 provides a low valuation, that doesn't necessarily mean the trustee is breaching their duties. A 706 valuation, depending on what it's for, could be lower or higher. A 706 valuation on a second spouse's death, where you're trying to minimize estate taxes, well, you're going to try to have as low of a reasonable valuation as possible. Or if you're trying to get a step up in basis for this first spouse, you're going to try to have a high 706, right? So it's so even with estate tax purposes, you can't read too deep into it without understanding what the purpose was of the estate tax. And when you have a particular transaction, you are still going to have to get an expert to look at the sale of this specific intellectual property. What fair market value as opposed to tax planning. So the sisters also complained about Danny's compensation, because that's another typical hot button issue. Because when you have a large, tens of millions of dollars, and you have a trustee serving, from the beneficiary's viewpoint, the trustees being compensated, and oftentimes that's a lot of money in compensation. If you have $100 million trust, that could be hundreds of thousands of dollars of compensation per year. Of course, from the trustee standpoint, the trustee is going to say, it's the worst job in the world being a trustee. I'm being blamed for everything, and it's a ton of work. I'm not just being paid to sit at home and not do anything. I'm dealing with a lot of issues. So there's two sides to that compensation story. But oftentimes there's a fight over whether compensation was reasonable or not. So in this case, Danny claimed that he was receiving reasonable compensation. The sisters said, no, you're paying yourself hundreds of thousands of dollars to harm the trust, so you shouldn't receive any compensation. So what's the standard? Under the California probate code, the first thing the court's going to look at is what the trust instrument provides. So if the trust instrument sometimes the trust instrument says no compensation. Or sometimes the trust instrument lays out precisely what the compensation shall be. Oftentimes trust instruments mirror the probate code and just provide for reasonable compensation. And so the question is, what is reasonable? And there's statutory authority and case law that guides the courts as to what is reasonable, but it's largely within the court's discretion. But the court can look at a bunch of factors, including the size of the trust, the complexity of the administration, the sophistication of the trustee. And so there's a list of things, the success of the administration. So if the trustee made the trust a ton of money, that's a factor, right? So there's a bunch of factors the court can look at in determining whether compensation in a particular administration was reasonable or not. It's not one size fits all. Not every $100 million trusts are the same. Every trust is different. So the court's going to look at each particular example to determine whether that particular compensation was reasonable or not. So in terms of the estate planners, you can try to get ahead of this issue by clarifying what the compensation is. And the two competing formulas are hourly versus commission. Hourly, it's how we bill as attorneys. The trustee or the fiduciary will just have to log their time, specify an hourly rate, and charge accordingly. Or the commission-based structure, which is how a lot of the corporate fiduciaries charge. So you could have a basis point, 0.5%, 0.7%, 1%, come up with a percentage as a commission-based structure. What I would propose is thinking about that in advance, especially since there's the possibility of litigation. And so when the estate planners come to me and say the trustees want to figure out their compensation, what I advise is get a couple bids. Go to a couple of the well-known corporate trustees. Go to some well-known professional fiduciaries. See what they would charge. Get a bid from them. put that in our file. Later, if there's a dispute, there was a basis as to why we decided to charge what the trustee did. It wasn't just some arbitrary number that we came up with. And ultimately, it's going to be within the judge's discretion, though. It could be you can charge what a corporate fiduciary would have charged, but the judge is still going to look at whether what you provided was of value to the trust or not. So, what are the practical lessons that we could take away from Mr. Bennett's estate? Transparency amongst beneficiaries can go a long way. And so the probate code requires sharing information, and there are instances in which a beneficiary oversteps and asks for too much information or is being overly intrusive or overly annoying, and it could be obstructive to administration. So there's that aspect of it. And then there's the other aspect of for the trustee of what's the harm of being transparent. Sometimes it's better to get ahead of the issues, put everything out there, and not start that slippery slope of mistrust, which often leads to litigation. Get ahead of the issues of diminished capacity to confirm control and oversight. So don't end up with this de facto trustee, lack of capacity, who's administering the trust dilemma. If you've got affluent, elderly settlors, famous settlors, think about control, think about oversight, think about advisors, put that proper framework in place. Think about reasonable compensation. Get those bids, like I said, talk about it, come up with a formula, draft a memo to file so that 10 years later, if somebody's arguing over how you came up with compensation, you could show the court that there was a reasoned process, which is going to increase the probability that the court's going to find the compensation to be reasonable. Clarify estate plannings for digital rights, royalties, and name and likeness. Oftentimes, estate plans neglect particular language about intellectual property, and then you end up with a situation such as this, where the lion's share of the trust is the intellectual property, but you have more of a generic trust that didn't really contemplate who's going to manage the intellectual property, like an intellectual property trust, a separate trust with a separate trustee and separate qualified advisors, for example. So we've got some estate planners who are terrific in that area, that deal with those issues beyond just standard estate planning. So if you have a famous client nowadays with any kind of digital rights, royalties, intellect IP, think about that in advance. Think about control and management of those rights in advance. And avoid competing disputes among competing children by appointing professionals. And so sometimes the perfect trustee still gets sued just because they don't get along with their brother or sister. And there's egos, there's entitlements. So sometimes getting family members involved leads to a fight, even if nothing's wrong. Asks for an accounting when nothing's wrong, right? Just because there's distrust there. So sometimes it helps to put in a corporate trustee or a fiduciary, even if it's as a co-trustee. Sometimes getting that neutral voice in there may make it harder for a discontent beneficiary to sue. So moving on to Jimmy Buffett, another very famous singer, songwriter, businessman, entrepreneur. Also died recently, about 3 years ago, 2.5 years ago, with an estimated estate of $1 billion, primarily consisting of his Margaritaville empire that he started later on in his career. And he had trademarks and a music catalog as well, sold more than 20 million records, member of the Rock and Roll Hall of Fame. And so in his case, there was a dispute amongst heirs regarding distribution of his assets and ongoing control of his Margarita brand, and questions about succession planning and blended families. So what happened here specifically is that his surviving spouse, Jane, with whom he was married since 1977, so long-term marriage, so this wasn't a new subsequent wife or anything like that, long-established wife, filed suit in Los Angeles, and then it was dismissed and refiled in Florida on those same grounds. And so we'll talk a little bit more about this later, but significance of court venue can play a big role. States have different laws, and something for estate planners to think about, and beneficiaries and spouses and all that to think about is the situs of administration. If you live in California, have a estate planning attorney in California prepare a trust in California, the default's going to be that California trust applies. Now, sometimes you don't want California trust to apply for whatever reason, and we'll talk a little bit more about that later with Rupert Murdoch. But some states have more advantageous laws. That California is I would say very um, rule intensive, and so cases cost a lot of money here. Cases last a long time here, and so some states may be advantageous depending or bad depending on your point of view, and so something to consider. But what could happen even if you establish a trust in California, if the settlers move out of California, which is what happened here, and you're living in Florida for a while, and your life's in Florida, and you pass away 10 years later. At that point, you may be far enough detached from California where the situs of the trust became Florida. So people also have to understand when you move, that could impact the situs of your trust as well, unless you specify specifically where you want the situs to be. So um, these large mega trusts, you should be talking to your estate planning lawyer and your professionals, your accountants about situs type concerns. It could have a major impact on trusts. So the surviving spouse Jane filed suit against the accountant who is the trustee, longtime accountant, claiming mismanagement, hostility, and excessive trustees fees. So in our prior example, we talked about appoint a professional neutral trustee. So in this case, there was a professional appointed, the accountant, but as we'll talk about, there was bad blood between the spouse and the fiduciary. So professional fiduciaries, if you're considering one, it there's advantages to picking the accountant that knows the family inside and out, but then there's probably going to be history there. So the accountant's not a truly detached neutral. So in this case, the wife didn't like that accountant. They didn't get along. So the wife sought removing the accountant in place of a third party neutral professional. So here's the exact language from the wife's petition, one of her paragraphs, where the wife says that the accountant's trustee is failing to perform his duties as a co-trustee, including not providing her information, leaving her in the dark as to the trust's affairs, disrespecting her, belittling her, and she claims charging an enormous fee, $1.7 million in 2024, to essentially run the trust in a way that she views was bad towards her. So let's talk a little bit about what the trust was here, to understand what was going on. So Mr. Buffett had created the trust in 1990. He had amended it a few times, including last in 2023, shortly before he died. And the trust included his interest in his Margaritaville brand, his investments, and it was hundreds of millions of dollars, if not more. And so the trust was primarily a marital trust. So the trust was set up to be for the benefit of his wife. And then after the wife passed away, after Jane passed away, it went to the three kids, um, which is a common estate plan that married couples do to set up marital trust to take care of the surviving spouse after they die. And then again to the three kids afterwards. So there was nothing weird about what happened after the wife passed away. It just went to wife and then three kids after her death. Pretty ordinary. The marital trusts. So marital trusts, oftentimes estate planners will talk to their clients and say, who do you want to make the decisions of the marital trust? If you make your surviving spouse the trustee of their own marital trust, they can effectively do whatever they want, subject to being sued by the kids as the remainder beneficiary. So do you want that extra check and balance? That's what Mr. Buffett did here. He established a marital trust, and he made it clear that it's for his wife's primary benefit. Um, but he required that they're at all times be an independent trustee that makes those decisions, discretionary decisions as to what the wife's going to get. So he was clear that he did not want the wife to decide for herself as to what she's going to get. But he had advisory language in there about the trustee to do what's worthwhile and in the best interest of the spouse, and to take into account, quote, primary regard for the best interest of the settler's wife rather than for the remainder or other successors. successor interests. And he had language to prefer income-producing assets. So, quote, unproductive property shall not be retained as part of the principle of the marital trust without the consent of the settler's wife. So Jimmy basically said, make this trust as productive as you can for my wife. Focus on my wife while she's alive. My kids will get when she's gone. Focus on my wife for now. So that part was good that he clarified that. Sometimes marital trusts are ambiguous and that can create a fight as well. So it's good to have some guiding language as to what the primary purpose is of the marital trust. So you've got this marital trust, you've got the wife who's upset, you've got this trustee she doesn't get along with. So and the trust gives that trustee she doesn't get along with discretion. So what are the limits to the trustee's discretion? It's damned if you do, damned if you don't in a lot of these situations where you don't get along, where the wife doesn't get along with the trustee, because the wife can ask for $1 million a month and the trustee can say, I'm going to give you 500,000 a month. The wife's upset. The trust. So you're always going to have that tension. So the standard is that what the court's going to look at is arbitrary versus reasonable decision making. In these discretionary cases, what I advise the trustees not to do is to not say yes or no arbitrarily. Because trustees are people too, right? They have their own history and impressions as you know, they can say, well, that beneficiary is this or that, they're a deadbeat, they're unappreciative, whatever the situation is, you do not want a trustee to make an arbitrary decision because that's going to create exposure. What you want the trustee to do is show reasonable decision making within the trustee's discretion. And so what does best interest mean? So this trust said, accountant, you have discretion to make distributions in Jane's best interest. So you want to show, so if Jane says, I want $1 million as trustee, you don't want him to respond and say, no, that's outrageous. What you want him to say is, can you please provide me a budget itemizing why you're requesting what you're requesting with supporting documentations and invoices? And so that way the trustee can make a reasoned decision. Oftentimes corporate trustees have panels and boards that make these discretionary decisions to insulate any argument of arbitrariness. So you want to put the beneficiary on the spot to provide you that information. Now, if the beneficiary provides you that statement and says, well, I want $1 million because I want a Ferrari and I want this and I want that and I want a 200-foot yacht, and it's completely contrary to what her usual standard in life has been, the trustee could say, no, nope, you're entitled to a nice car, you're entitled to a yacht, but it's not going to be the ones you're requesting because that's not how you've lived your life the past 20 years. That's not how you lived your life with Jimmy. And so this is what I'm going to give you instead. I'm exercising my discretion to deem this is in your best interest. That's much harder to refute at that point if you go to court than if the trustee just said no. So you want to make sure to avoid arbitrary decision making. There's also, of course, a tension between current and remainder beneficiaries. Anytime you have a marital trust, the spouse wants as much money as possible while she's alive. The kids, especially if they're not her kids, want as much money preserved for after her death. And so the trustee owes duties to both the current and remainder beneficiaries. Now, if you have a language like you do here, where the settlor directs the trustee to prioritize the surviving spouse, that insulates the trustee a little bit from front-loading more money to the surviving spouse now. But the trustee still owes duties to all beneficiaries. So the trustee has to show that he or she is reasonably exercising her discretion to not only take care of the marital trust spouse, but to also preserve money on the back end. So there's principal growth, and you're not diminishing the remainder interest for the remainder beneficiaries. And so that, of course, raises issues of asset allocation. Are you buying assets that prioritize income, or are you buying assets that prioritize principal growth? And again, the court's first going to look to what the trust says. In this case, the trust said prioritize income growth. And so again, that gives the trustee direction on what types of assets to purchase. So the wife here claimed lack of transparency. So like our prior example, she said that The trustee's doing stuff. I have no idea what the trustee's doing. I'm asking questions. I'm not getting good answers to my questions. I don't think the trustee's properly investing. The trustee's not really explaining the investments to me. Um, I think the trust is worth $275 million, but it's only producing $2 million in net income. That's a bad return for a trust that's worth that much. Uh, and the trustee responded, "You're wrong. That's not, your assessments are incorrect. You have to create adjustments to your life and to your expenses because you're wrong as to what you think the trust should generate." So again, you can have the wife's a beneficiary. She can request accountings and she can look at what the trustee's investing in, and she can challenge the trustee's decisions. And the court within the business judgment rule is going to give the trustee some discretion if if what the trustee is doing makes sense. Now, if they're entirely unreasonable investments, like $100 million sitting in a non-interest bearing account, then the court's going to critique that. But so there's going to be some tension over what the trustee is doing. And of course, the wife was challenging the trustee's fees, saying, "I don't think you're doing a good job, but yet you're paying yourself all this money." Um, the trustee claimed that this is what Jimmy wanted. He wanted me to manage your assets. He wanted me to make these decisions for you, and you're just angry I'm in charge, and you don't like the way Jimmy structured the trust, but that's not my problem. I'm just doing what the trust says. So the issue is really about control. The wife wasn't very thrilled that you have this accountant she doesn't like in the way that's deciding what she gets. The wife requested removal of the trustee, with the goal there being, I think, she made a calculated decision that if I get rid of Mazinter, the accountant, I think I'm going to get along with the new trustee better. And there's a higher chance that the new trustee is going to not give me a hard time or go along with my discretionary requests. And so under Florida law, removal is possible where it serves the best interest of the trust, or where there's unfitness, unwillingness, hostility amongst the trustee, lack of cooperation amongst the co-trustees. California law, similar statute, section 15642 lays the grounds for removal. So ground for removal for breach of trust, if a trustee is unfit to serve, hostility or lack of cooperation, or excessive compensation. And under California law, a trustee can be suspended at any time pending removal. So court has wide discretion to suspend pending removal. Here's another statute, Nevada, similar standard. So a lot of states have the same removal provisions. So the wife was seeking removing Mazinter. So Mazinter in turn sought to decant the trust. So he filed. He said, "You know what, Jane, you're at this point. You've got an axe to grind with me." And then Jane also had a power of appointment, so she could have reapportioned amongst her children who received what after her death. So Mazinter was afraid that Jane's going to try to weaponize the trust to get her children to be on her side to get rid of him. And so he sought to decant to take the wife out as trustee and to strip her of her power of appointment. And so that was kind of his responsive play, in response to her trying to get rid of him and suing him for breach of duty. And so that case is still pending. So what is decanting? Decanting, we'll talk about it in a little bit in relation to the Rupert Murdoch case, but it's available in different jurisdictions to allow you to essentially, just like it sounds, decanting wine, it allows you to pour one trust into another trust, effectively changing some of the provisions of the trust, such as who the trustee is and the terms upon which a beneficiary can receive. And every state, every jurisdiction is different. Some states are much more um, uh, limited in terms of what you can do with decanting, and some states are very flexible with decanting. And so we'll talk about that in a little bit. So what happened here? You've got all these claims, the court ordered mediation. We'll talk about mediations a little bit, but oftentimes what happens in these sticky cases, the court asks you to go mediate. So Jimmy Buffett practical lessons. Consider tensions with surviving spouses and use of discretionary trusts. Spouses are not going to be happy you're putting a middleman in the way to decide what they get. So think about that dynamic and plan accordingly. Pick the right trustee. If it's someone that the beneficiaries get along with, of course, do you want them to be qualified and you want them to be firm and do their job properly? But if it's a trustee where there's some tension there or bad blood, there's going to be potential problems. Have a contingency plan. Talk about who you want to be the second or third trustee just in case. Get ahead of the issue of trustee transparency, like we talked about as trustee. Maybe share information to avoid claims that you're hiding something or doing something wrong. Document due diligence and discretionary decisions. So get ahead of that argument that you're being arbitrary. Show that you're exercising discretion reasonably, that you're not being arbitrary. And then use proper advisors to determine allocation of assets among income producing and prudent investing, so that you're not dealing with arguments over the tension between remainder beneficiaries and current income beneficiaries. So if you have advisors, the proper advisors, wealth managers, and so forth, telling you how to prudently invest as a trustee, you're insulating yourself from, again, arbitrary arguments and breach of duty type arguments. So our third case example, Rupert Murdoch. This was the inspiration for the HBO show Succession. And so Rupert Murdoch, 94 years old, still alive. He's known for owning Fox, or a large share of Fox is his involvement in Fox News. And so this case was about trustee succession and Mr. Murdoch's ability to try to direct who's going to control his empire of his irrevocable trust amongst his children, and how that all played out. So this case was pending in Nevada. The reason why it was in Nevada was because Nevada has, amongst the many reasons, Nevada is I think more of a trustee-friendly state, more of a settler-friendly state than California is, or some other states are. And so Rupert Murdoch kind of wanted Nevada to be the playing field. He felt that gave him the best chance. But Nevada allows sealed trust records. So in California, it's a very onerous process to try to seal court documents, and it requires filing a motion every single time you want to try to seal something. Nevada has a more robust sealing procedure, where, look, I mean, like even the case title was the matter of the Doe One Trust, right? So in California, you'd have the name of the trust, but still information leaked through the media, as it often does. And so what happened here is you had an irrevocable trust that provided Rupert's 4 children are the co-trustees. But fast forward to now, Rupert was concerned that his children's political ideologies differed. And so if they became the co-trustees with the voting shares to Fox, they could essentially change Fox from what his vision was of what Fox should be. And so he didn't want that to happen. So he decided he wanted one of his children, Lachlan, who was most aligned with his ideology, to be the trustee. So he had an irrevocable trust. He wanted to change his mind. So Mr. Murdoch filed in Nevada, seeking to modify the trust under Nevada jurisdiction. Why Nevada? Because he met with his lawyers and advisors, and Nevada had more flexibility than, say, California would have to do this type of a modification. And so Nevada has a procedure for the court to take jurisdiction over a trust, even if it's not a Nevada trust to begin with. And then there's more flexibility to try to modify the trust. So California is pretty limited on how you can modify an irrevocable trust. Nevada has more opportunities for that. But it still didn't work initially. In a 96-page sealed ruling, parts of which leaked. Again, it was supposed to be sealed. The whole point was that he wanted to try to do this under seal so that if it didn't work, nobody knew. Parts of it still came out. The court said that Mr. Murdoch's request was in bad faith, called it a carefully crafted charade to permanently cement Lachlan's executive roles. And so the court essentially said, you had an irrevocable trust to the 4 trustees, to your kids. You did what you did. You can't completely change that now to only make one of your kids the trustee. So the court didn't allow it. So Rupert Murdoch then threatened to appeal and sell the company, which he could have done as trustee of his trust. He could sell the assets of the trust. And so he said, I'm going to sell the company then. And so that forced the parties into mediation. And they globally settled at the mediation as part of a $3.3 billion settlement. So they agreed in settlement that Lachlan will maintain control over the voting shares of Fox until at least 2050. And those other three siblings each received $1.1 billion each. And the half siblings remain non-voting beneficiaries in the trust and entitled to assets when they turn 30. So they essentially agreed on distributions in exchange for maintaining the voting rights. Probate court approval of settlements agreements. When's it necessary? In Nevada, again, there's loosened rules as to when you need probate court approval of settlements agreements. California, you don't need court approval in California, but oftentimes you want it because you want that settlement to be binding against all beneficiaries, including sometimes unborn people or persons who didn't participate in the case. You don't want someone to come out of the woodworks later and claim, I didn't agree to this or that. So the probate court approval of the settlement makes it rubber stamps the settlement and makes it binding against all people involved in the trust, so that there's a major benefit to that. And in fact, in California, there's a somewhat recent case called Breslin v. Breslin, which many of you are familiar with, which says that the courts in California can compel parties in a trust to mediate as part of the court's role as a super fiduciary, where usually mediation's optional. You can't compel mediation, but you can in trust matters. So what are the practical lessons of the Rupert Murdoch case? Risks of irrevocable trusts. Irrevocable trusts are great and they have significant benefits, including tax planning. They could be invaluable when it comes to tax planning, but think ahead in terms of what kind of flexibility you need. You can maintain some flexibility in an irrevocable trust and still get the tax benefits. And so I don't think Rupert he didn't think about the situation where well, who's going to run Fox News 20 years from now, right? He didn't think about that situation. What if my kids disagree with me? I guess he presumed his kids are just going to go along and do what he wanted, and everyone's going to think like he is. So he didn't think about that issue. So think ahead. Think about succession planning. Think about who's going to control your empire, especially these big celebrity cases. Think about contingency plans, using trust protectors, maintaining the ability to swap trustees. So there's different things you can do if you plan ahead. But complex succession planning must anticipate conflict. And there's always a planning for control versus benefit, right? Regardless of who benefits with these big empires, you're running companies, control matters sometimes more than who benefits. So think about those issues in advance. Think about public exposure and opinion. These cases are highly sensitive. The public wants to know what's going on, and sometimes these trustees want to keep things under wraps. And so there's certain states where you can do things under wraps. There's things you could do. So estate planner should think about that from now and talk about dispute resolution protocols and so forth to try to avoid some of this stuff spilling into the public forums. And also, of course, there's tax consequences to all this that you should think about. Always advise the tax professionals properly. You can apply for private letter rulings on a lot of these issues about, changing an irrevocable trust. Is it going to reopen my estate up to estate taxation for assets that I removed from my estate? So get the right professionals involved and make sure you think about the big picture and not just the specific problem you're dealing with, and plan accordingly. And that's that. And so I think there's a minute or two. We're probably out of time. But again, if any of you have any questions, feel free to reach out to me. And again, I want to thank the Beverly Hills Bar Association for having me here today and allowing me this opportunity.
Thank you, Vachi. This concludes today's program. We'd like to again extend our thank you to Vachi for an excellent presentation. Our next program will be on February 17th, and speaker will be Kristen Mattioni of Whittier Trust, and we hope to see you then. Thank you all for joining us this afternoon.